All right, today we're going to talk about the principles of liability. Liability for some sort of injury is a big fear of most doctors. An injury can include not only physical damage, but damage to someone's rights, their reputation, or their property. Improperly disclosing someone's health information is also a type of injury that someone can sue over. So that's why it's important for health information professionals to have a good understanding of all of the principles of liability. So before someone can sue someone else, they have to prove that they have some sort of relationship with the person. There are many types of healthcare relationships, but the three most common to lawsuits in the healthcare field are physician and patient, hospital and patient, and hospital and physician. The physician-patient relationship also applies to other healthcare providers like nurses or physical therapists, okay? It's not just doctors. But this type of relationship begins when the patient requests treatment and the physician or other healthcare worker agrees to do it. This is contractual because it has the two necessary components. So the patient is requesting treatment and the acceptance of the offer, the doctor agreeing to do the treatment. And this relationship can also happen through websites, like, when you can search a question about a medical issue you're having, and there are websites where doctors will give responses. Even though they've never met you or whoever, there is a physician-patient relationship established. All right, this relationship lasts until either the patient no longer needs treatment, the physician or patient decide to leave the relationship. For that one, the physician does have to give the patient notice. They mutually agree to end it if the patient dies or if the patient doesn't follow the doctor's orders. Okay, so most of the things we just talked about also apply to the hospital-patient relationship. This one begins when a patient is voluntarily admitted to a hospital. When you're admitted, in all that paperwork you fill out, one of the things that you sign says you agree to pay for whatever treatment you receive. That right there establishes a contract. This relationship ends when the patient is discharged or leaves against medical advice. Hospitals are not required to treat every patient that walks through the door. The only exception is in an emergency care situation if the hospital has an emergency room and they accept patients with Medicare. Under EMTALA, that's the Emergency Medical Treatment and Active Labor Act, the hospital or physician is required to treat someone that comes in active labor or in an emergency medical condition until they're stabilized. At that point, then they can either continue treating them, transfer them to a different facility, or discharge them. Okay. Now, the hospital-physician relationship is not based on direct patient care, but the contract that allows the physician to treat their patients in the hospital. And the hospital and the physician work together to treat the patient. So this one starts with the credentialing process, where the hospital's governing board looks at the physician's background, what experience they have, what are they licensed, and all that. And then the hospital will decide what medical staff privileges the physician will have. And if the physician violates any of the standards for care, quality, or conduct, then the hospital can terminate the contract. All right. Moving on, most lawsuits in the healthcare field can be divided into three areas: breach of contract, intentional tort. If you remember, we talked a little bit about tort in Chapter 1. So intentional tort is when someone does something with the specific intent to do something wrong. Examples would be assault and battery, defamation, invasion of privacy, false imprisonment, which is, keeping someone against their will. And then non-intentional tort. That's when someone commits a tort without the intent to do something wrong. Okay, so we're going to go into these three things. The next 15 slides are going to talk about the different types of non-intentional torts, starting with negligence, which is failing to do the right thing. Okay, or it can be the opposite, doing something that you shouldn't do, that a normal, reasonably prudent person would not do. Okay, malpractice refers to professional misconduct, and then medical malpractice is just specific to healthcare providers, with the patient ending up being harmed because the physician or the nurse didn't follow the proper standard of care. Like I said, it's not only doctors, it could be with any healthcare provider or even an institution. There just has to be either a patient-physician or a patient-hospital relationship established first. That's the very first thing. Okay, to win a medical malpractice case, the patient needs to prove 4 things: that a duty of care is owed to the patient, that there was a breach of that duty, that there's a causal connection between the breach of duty and the patient's injury, and what were the damages? What was the injury or the harm? Okay, so what do all those things mean? Duty of care is an obligation, so it requires someone to follow a particular standard of conduct towards someone else. Doctors follow certain standards when treating patients, or at least they're supposed to. If someone has a certain symptom, there are, certain paths they can follow to treat that symptom. Most physicians will follow generally the same paths, right? But this isn't just for the medical field, right? Even you and I have a duty of care when we drive our car. We have a duty to drive carefully and follow all the laws, or else we'll be held liable if we get in a car accident. Okay? So the plaintiff has to prove that the defendant did not follow the standard of care. In a medical malpractice case, the evidence can be these things here. So standards, laws, and regulations that are important to the profession, written materials that the professional association has put out, the policies and procedures of the facility, and expert testimony from another professional in the same role. So another doctor that does, the same, like another surgeon, if it's a surgeon being tried. Okay. After the patient proves that the physician did not follow the standard of care, he has to then prove that it was this breach that caused their injury, and that without the breach, they would not have this injury. Okay, this is called causation, or sometimes called causal connection. So proving the causation can be hard because sometimes all or part of the injury is not the direct result of the physician's negligence. The test to determine this is called foreseeability, meaning if the physician had anticipated whatever caused the harm, then the injury is considered foreseeable and the physician would be held liable. I know you can't answer me, but I think, just to challenge yourself, like if you were in this situation and had to prove this, which of those types of evidence from the last slide do you think would best help to prove foreseeability? Would standards help, written materials, policies and procedures, or expert testimony, someone else that does that job? So think about it. Actually, if you come up with an answer, email me what you think it would be and your reasoning behind it. What would be the best form of evidence to prove foreseeability, and why you think that? And I'll give you 2 bonus points on an assignment you didn't get 100 on. All right. Okay, once you can prove the link between the breach of duty and the injury, the patient is entitled to damages, which can be nominal. If it's a minor injury, they can receive just like a small amount of money, sometimes only $1. So like if the patient is technically right and something negative did happen to them, but there wasn't really a big injury or anything to show for it, they would receive nominal damages. Actual damages, also called compensatory, these compensate for actual loss. Okay, all medical expenses, any loss of income, past or future. It's meant to make the plaintiff whole. And then punitive damages, also called exemplary damages, because they're above and beyond actual damages. If there's proof of outrageous, malicious, or intentional conduct to hurt someone, this is used to kind of make an example of the wrongdoer. Medical malpractice cases don't usually get punitive damages because most of them are just based on negligence, like just not following the correct path, as opposed to being outrageous. But speaking of outrageous, if you've never listened to the Dr. Death podcast or watched the miniseries, it's a really good example of malicious conduct by a doctor. All right. There is a second negligence theory called res ipsa loquitur, which means the thing speaks for itself. That can be the basis of a medical malpractice action if the plaintiff cannot prove negligence with the evidence they have. So with this theory, the plaintiff would have to convince the jury that the injury would not have happened without the physician's negligence. And then the physician side would have to kind of prove otherwise. Okay, so they kind of leave the burden to prove it on the physician, because it kind of makes sense if you think about it. The physician has better access to the evidence of what happened to the patient, because, in the example here, if a foreign body is left in a patient after surgery, the patient's asleep. They don't know what's happening. Okay, the doctor does. So the patient has to prove that the injury would not have occurred without negligence, that the doctor was the only one that had control over the instrument or to cause the accident, and that the patient couldn't have caused the accident. Okay, the next non-intentional tort we have is vicarious liability, or respondeat superior. So this makes the healthcare organization or the hospital responsible for the acts of its employees if the employee is within the scope of their employment. If the jury doesn't find the employee or the physician liable, then the employer or the hospital cannot be held liable either. So to determine if an employment relationship exists, the court's going to look at who selected the employee, who pays them, who can fire them, who has the power to control the details of the employee's work. So the control one is the most important. If they can prove that the hospital or the employer has control over the employer's work or employee's work, then an employment relationship is usually found. In the healthcare field, hospitals are usually held vicariously liable for negligent acts of nurses or interns, residents, technicians, because they're employees of the hospital. So they have that control over their work schedule or their tasks, or what things they're going to be doing each day, as opposed to physicians, who are usually independent contractors, right? So they're not technically employees of a hospital, so they cannot be held vicariously liable, unless the doctor is a hospitalist. So that is a doctor that is an employee of the hospital. So normally when a patient comes in, well, not normally, but sometimes when a patient comes in, they're already under a doctor's care. So their doctor's going to come see them while they're in the hospital, make rounds on them and all that. If a patient comes in and is not already seeing a physician, not already under one's care, then the hospitalist that stays on staff will see those patients, okay? So hospitals could be held vicariously liable for hospitalists, doctors that are hospitalists at their facility. Okay, hope that made sense. All right. Unlike vicarious liability, corporate negligence says that a healthcare organization or hospital owes a duty directly to a patient in regards to care and treatment. It says basically that the hospital is supposed to provide everything according to the standard of care that the patient needs. So this includes making sure medical staff is properly trained and skilled and has, all the appropriate credentials. Corporate negligence was first used in the case of Darling versus Charleston Community Memorial Hospital. What happened here is a college football player broke his leg during a game, and the on-call doctor in the emergency room didn't have any orthopedic training, but put the cast on the little boy. And he did it so badly that it was impairing his blood circulation. The guy complained, like multiple times that it was hurting, but they never did anything about it. It stayed on his leg for 14 days before he moved to a different hospital. So when the doctor there removed the cast, because there was no blood flow for 2 weeks, the tissue had died and he had to amputate the boy's leg. Okay, so the first hospital was held liable under corporate negligence because they had a duty to make sure the patient was examined by a physician that had proper orthopedic training to make sure that the cast was put on properly. In the second one, Johnson versus Misericordia Community Hospital, the hospital gave staff privileges to a doctor who had been already accused of negligence, and they didn't properly investigate their training and their credentials. And so the hospital was held liable in that case as well. Okay. Failure to warn can also be called failure to protect. This is another negligence theory that applies to a psychotherapist's failure to take steps to protect an innocent third party from a dangerous patient. Which is what happened in the case of Tarasoff versus Regents of University of California. If a patient tells their psychotherapist that they plan on hurting someone, or if it's implied, the psychotherapist has the duty to either warn the potential victim or to tell the police. Okay? All right. The next non-intentional tort is breach of confidentiality, which is the unauthorized acquisition, access, use, or disclosure of protected health information that compromises its security or privacy. It is not a breach when an unauthorized person that has been given access to the information cannot reasonably retain it or keep it. Okay? Breach of confidentiality has been recognized under the law for a while now with the passage of HEIT, the HEIT Act of 2009, which is the Health Information Technology for Economic and Clinical Health Act. And it's considered a federal offense under HIPAA. Okay, if a breach occurs, the physician or someone that works for him has to let his patients know within 60 days. Okay, of 60 days from finding out there was a breach, they have to let the patients know. They also have to notify the Secretary of Health and Human Services. Now, if it's more than 500 people that are affected by the breach, the secretary has to be notified immediately. If it's under 500, they only have to notify them like each year. So if like 10 people have a breach this month and 5 in another month, which hopefully that's not happening, they would notify the secretary of all 15 of those one time that year. They're also required to notify the big media outlets in the area because, of course, the media is going to want to cover it. Who doesn't love a scandal, right? Now, each year, the Secretary of Health and Human Services creates an annual report that they give to Congress that summarizes all of the breaches in that calendar year. A few years ago, they identified the 6 general causes of these breaches: theft, loss, unauthorized access or disclosure, improper disposal, a hacking or IT event or incident, and then unknown other. Okay, usually after a breach, healthcare providers will revise their policies and procedures, improve physical security, provide additional training for their employees, adopt encryption technologies to protect against like hacking. They'll revise their business associate contracts. So if it's someone that they contract with that caused the breach, like a paper shredding company, then they would maybe, think about, should we still have this contract with them or should we use someone else? Perform new risk assessments, impose sanctions on employees for violating policies and procedures, and provide free credit monitoring for impacted individuals. Okay, like I said earlier, it is a federal offense for the people that are involved in these breaches. They usually have to pay a fine or go to prison or both. It really just depends what their intentions are. Were they stealing the information under false pretenses for personal gain, for malicious harm, etc.? Okay, done with non-intentional torts, moving on to intentional torts. So even though assault and battery are usually lumped together, they're actually two separate torts. Assault is a threat that does not involve physical contact, and battery is physical contact involving injury or an offense. Obviously, the victim does not give permission for either act. And then on top of being considered a tort, assault and battery are both considered a crime. Medical professionals are not usually accused of assault and battery, but when they are, it's usually an accusation of technical battery, meaning while treating a person or a patient, they exceed the consent given to them by the patient, such as performing surgery on the wrong body part. That's a big no-no. All right. Defamation is wrongfully trying to hurt another person's reputation. It can be either in writing or pictures, which is considered libel, or verbally or by using gestures, which is considered slander. So for either, the defamatory statement must be published, meaning it has to be made to a third party, not just the patient. Okay, invasion of privacy is sharing someone's information, sharing information about someone's personal matters. To use this tort, the plaintiff must prove one of these things. There was unwarranted appropriation or exploitation of their personality, a publication of their private affairs, which would embarrass them, wrongful intrusion or invasion of their private concerns or activities, or some sort of publicity that paints them in a bad light. An example of invasion of privacy in the healthcare field would be using someone's before and after pictures from a surgery without their permission, or giving out their personal information without their permission. Okay. Medical abandonment is when the physician stops treating a patient without giving them notice, and they still need to be treated. So to prove this, the patient has to show first that there was a physician-patient relationship, and that the abandonment caused whatever injury that they're suing about. Physicians have been found liable of medical abandonment lots of times for things like leaving their patient alone at a critical time, or not being available because they're tending to another patient, or they're on vacation, or the doctor thinking that the patient had recovered and no longer needed treatment, so they discharged them before they should, and then maybe something happened to them after that. Patients have also made claims of medical abandonment because their doctor didn't respond to their email or blog or whatever asking for medical advice. If the doctor had already started a relationship by communicating with them through social media or email, then it helps that patient's claim. Okay, false imprisonment is holding someone against their will with no legal justification. It's sometimes confused with false arrest, which is the same thing, but with the intent or actually making the arrest. The intentional infliction of emotional distress tort is used if a defendant's conduct is so extreme and outrageous that it causes the plaintiff to experience severe emotional distress. And they did so intentionally. So this is not just, your supervisor cursed you out and you got upset. It has to be really bad and require medical care after. Okay, a breach of contract usually involves an express contract, meaning the parties agreed in advance upon a specific treatment, or the physician guaranteed a cure and fails to deliver on that. The patient can sue under the theory of non-performance, and these examples are actual cases. So the first one, a doctor agreed to treat someone for tuberculosis and then did nothing. And then in the other case, a doctor agreed to perform a hysterectomy, but then didn't. So they were both held liable for breach of contract. Now, while social media has been good for patients being able to more easily talk to doctors and have their questions answered, it's also opened up the door for more doctors being sued, because once they begin that provider-patient relationship by giving that advice, that medical advice, the responsibility for that patient falls on them. Okay? And since doctors have to get licensed in their specific state, if they treat a patient over social media that lives in a different state, they could be subject to a claim of unauthorized practice of the provider's profession. A physician can be subject to malpractice claims or claims of professional misconduct if they don't have a full understanding of the patient's condition, right? And they give medical advice that results in the patient being harmed because they don't know that the patient is giving them all of the details, right? Or they don't have the blood work or lab work or whatever it is necessarily that they need to make an informed decision. Social media is also a privacy and security risk if the doctor responds with patient-specific, like protected information, and the patient has not given authorization, or the response is not encrypted. It could be considered a security breach. So to help mitigate these risks, doctors can get authorizations before offering advice, use disclaimers, or encrypt their responses. But honestly, I don't know why doctors even still do that. It's such a high risk for them to get sued. I don't think it'd be worth it. Okay, now we're going to talk about some of the defenses that are typically used in lawsuits by healthcare providers. First, we have statutes of limitations, which is a law that sets a fixed time period for when a lawsuit has to be filed. And if it's not done within that time frame, then the case is automatically dismissed. The main reason for this is so that when the lawsuit is filed, everyone's memories are still intact and evidence is still available. If someone waits, 20 years to file a medical malpractice claim, chances are the doctor's not going to remember them. Okay, the time period will depend on what state you live in and the type of suit. Is it a tort case or a contract case? It can be extended for minors or someone with like a legal disability, or in the case of a foreign object being left in someone's body, the time frame doesn't start until the foreign body is discovered. Okay, a charitable hospital is a nonprofit hospital that treats people that are uninsured and can't pay for it themselves. So in the past, a charitable hospital couldn't be held liable for any torts that happen in the hospital or by its employees. And the reason it was this way is so that the money they were getting would be used to treat the patients instead of paying for damages after a lawsuit. But this is no longer the case. Now they can be held liable for injuries just like any other business. But that was referred to as charitable immunity. All right, this is a fun one. Governmental immunity says that federal and state governments could not be sued over negligence of one of their employees or officers unless they consented to the lawsuit. So they had to agree to be sued. So I'm sure it happened very often. The of this is based on the English common law concept that the king could do no wrong, so him and his subordinates could not be sued. Now, most jurisdictions don't really use this anymore, and they do allow tort lawsuits, but of course there are some limitations. Okay, a lot of states have what's called Good Samaritan statutes to encourage doctors or other people to give emergency treatment without being held liable if something bad happens to the person, from them trying to help them. Unless the person is not truly trying to help or is acting reckless. So this is not for like emergency room physicians. It would be for when something happens in a non-traditional setting, like someone having a heart attack on an airplane, or someone that got in a car accident. Okay, contributory and comparative negligence are sometimes used interchangeably, but they're two different things. So contributory negligence is when something the plaintiff did contributed to their injury. So even if the plaintiff proves every part of their negligence claim against the defendant, they will still lose if the defendant proves that the plaintiff contributed to their own injuries. Comparative negligence is very similar. It's just not as harsh. So if that happens, then they don't just automatically lose, but the amount that they get in damages is reduced depending on how much was their fault, like by a percentage. Okay, assumption of risk is basically says if the person knew going into something that there was a possibility of injury or harm and still did it anyway, then they can't recover damages for that. The defendant would have to prove that the plaintiff knew about the risk and still did the activity voluntarily, like breaking your leg while skiing. Okay, last but not least is apologies. So I touched on this last week. Several states have passed laws that let a healthcare provider apologize for their mistakes without fearing that their apology will be used against them in court as like an admission of their liability. And they're passing these laws in the hopes that if doctors start apologizing to patients or their families, it'll just lower the chance of them wanting to file a lawsuit. All right, and that's all I have for you today. Hope you have a good week and good luck.